I'll tell you this. Hey, how about this? Why don't you go over into Wayne County Jail? I'll give you $100,000 if you stay the night. You're like, man, I ain't doing anything tonight. I'll take it.
Yeah.
But you had a choice, and my client didn't. How arrogant to think that making a choice versus having somebody's dignity and human rights and civil rights and constitutionally protected rights to be stolen are the same thing.
Hey everybody, welcome to Cases Gone Wild with me, Jon Marko. I'm your host. As you know, this is our podcast brought to you by Marko Law. Please, if you like our show, if you find us somewhat interesting, if you enjoy listening, please follow, please share to your friends so we can reach more people. Today's episode, we're actually having a multi-volume show with the esteemed, the famous Jim Harrington IV of the Feiger Law Firm. If you were listening last week, this is the continuation. If you weren't, go back and listen to Volume 1 so you can continue to hear these absolute cases gone wild. And I'm very excited to continue our story with Jim about some of the craziest, wildest cases that you'll ever hear.
I'll never forget, people, please call your next witness. The people called James J. Harrington to the stand. And so as soon as I start to walk in, all the heads look right at me. And all I could think about was, oh my God, don't trip. So I walk up, I see, it was horrible seeing Jeff and Ven sitting at that. I mean, they belong in a courtroom, not there.
Yeah.
And so I got called to the stand, and the government started, asking me a few questions, and he's nervous. I could see his hand was shaking.
The government
was, and I was almost sick to my stomach, and so he starts asking me questions, and there's this real slow burn to this. It's almost like this methodical buildup. And you wrote the check on this date. Yes, I did. And is that your signature on the check? Yeah, it is. And that check was for $2,500. Yes, it was. And then they go, can I direct your attention to the board in the back? Is that your bank account? Yes, it is. And can you tell us how much money you had in your account? $347. And then he goes, this was the best part, because it was like a slow burn, right?
Yeah.
And then his next question was, now, Mr. Harrington, if that check had cashed on the date of that account being $347 in your account, how much would be left? And then, like, the microphone was right here, and I lean up, I go, not much. And the entire jury just started laughing, and and it was fine. The rest of the exam was what it was.
Yeah.
And then Jerry got up to, I guess, cross-examine me, and I'll never forget it. It was almost like it would have been like if a kid had a chance to play catch with, like, Mickey Mantle.
Yeah.
I'm sitting there because at this point I'm a young trial lawyer, and I've already emotionally committed that this is what I'm going to do for the rest of my life. Yeah. And by now,
your boss, with the greatest trial lawyer ever, is sitting there in the defense, and then you have Jerry Spence, the next greatest trial lawyer ever.
So Johnny, I'm sitting there and I'm watching, and I'm looking at Jerry, and his voice is so mesmerizing. If any of the listeners here have a chance to just listen to Jerry, pull him up on the internet and listen to his speech, he's
like a calming dude.
It's incredible.
Did he have his leather?
No, he had on
a Detroit suit.
Yeah,
okay,
he had on a suit. And so he started asking me questions, and I'm going along and answering the questions, and then all of a sudden, I just, like, blurred out, like, I'm just staring at him, listening to his voice, and it was just, and I didn't even hear what he asked me, and he said, Jim, and I said, Mr. Spence, I apologize. I completely zoned out. I didn't hear anything you just said. And he said, it's okay. And then he went back into it. And then what he did with me during his exam was he completely reframed what it was that the government was doing. And he started creating this defense of this government oppression, this witch hunt, this we're going to get Jeff Feiger. And he started painting that picture.
How did he do that?
So he asked me, he goes, now, Jim, can you tell us what it was that you saw when you pulled into the office that night of the subpoena? And so I said, Mr. Spence, I had no idea why I was going there. I just knew that there was a subpoena. I knew nothing about. I had been given no explanation, and I pulled into the parking lot, and I can tell you, and this is what I said at the trial. I said, and all I could see, Mr. Spence, were agents everywhere, from as far to my left to my right as they were coming in and out of buildings, and I said to him, I said, and Mr. Spence, I don't know if you've ever seen the movie The Matrix, but they have this character called Mr. Anderson. And
the guy with the black sunglasses? The
black sunglasses, the trench coat. But what Mr. Anderson would do in the movie, Mr. Spence, is they could multiply.
Yeah.
And when the good guy was fighting the Mr. Andersons, he would multiply and be a much more formidable opponent. And that's what it looked like, Mr. Spence, a scene from The Matrix where across the entire parking lot was nothing but Mr. Andersons.
And that's genius, Jim, because a lot of lawyers less skilled and lawyers would say, that's all irrelevant. What does that have to do with the case, right? But I think it had everything to do with the case.
It was the catalyst for the defense theme because, and listen, that was what I just thought of at the time, and I hadn't really had much conversation with Jerry or with Steve Fishman about the theme. I really didn't know what it was, and really it wasn't until that ruling that the landscape of the case kind of changed. But from my perspective, I always believed that this was a witch hunt. It was a oppressive government, and so when I laid out that theme of the Mr. Andersons, I wasn't the only one that felt that way. A lot of the other witnesses kept talking about how heavy-handed the government. One person did say in testimony that there were more agents looking for Jeff Feiger than Osama bin Laden, and there was just all of this type of heavy-handed government.
I mean, they flew. My recollection is they actually flew in FBI agents from other states because they didn't have enough in Michigan to do what they wanted to do.
Yeah, I don't know. I mean, that wouldn't surprise me given the number of agents that I've seen, but I don't know that to be true.
Yeah.
But I mean, people that you may have talked to that have been maybe closer to the trial.
Yeah.
Well,
you were pretty damn close, dude. So I don't know. So I guess we all know what happened.
Yeah.
We all know ultimately what the jury did, and they shared in Spence's and your belief, right?
Yeah, and so the trial was interesting, and I think if you were to talk to the people like Venn and some of those folks in the camp that, I've heard that the reason that they won was because of Fishman, or the reason they won was Spence. It depends on who you are.
I've heard that too. Differing people say different things.
Here's my opinion. I mean, you could get if we're watching a Lions football game and the Lions win. Everybody watching is going to have an opinion as to why they won.
Right. Was it Stafford? Was it
Goff? Was it the defense? Whatever. So here's my opinion. My opinion is that as gifted as Jerry was and as gifted as Fishman, it was in the trial, that I don't know if they would have won absent the other, meaning that the two of them were so good in their own
different ways, right?
And it's an interesting lesson in trial advocacy because Jerry tries a completely different case than Steve Fishman. Steve tries a different case than Jerry. Steve is razor sharp. He's 10 steps ahead of you, and you can't keep your eye on the ball, and next thing you know, he's got you as a witness. He's so gifted. And Jerry does a different, more human approach, and he gets into the feelings and gets into your soul, and they're two totally different approaches. But I think the two of them together was
covered
the
everything,
perfect
right?
recipe for the result. and it was such an incredible process to watch. It was a horrible process, to watch because of what was at stake. But
looking back,
but with the
what an
retrospect,
amazing story. Right?
Yeah, the retrospect benefit of looking at this and knowing what the end result was, that it was an incredible lesson, for myself in trial advocacy as to seeing different styles and how they were able to win the case. And man, when the acquittal came in, it was like one of the I can't imagine the relief and vindication that Jeffrey and Ven had felt. But from
their
my
whole lives
perspective,
were on the line, man.
their entire livelihood.
Not many lawyers can say that. We say this is the most important case in my life. This really is the most important case of your life because like you said, we lose a case.
Right.
It sucks. We might lose a lot of money. Our clients might lose a lot of justice. It's a horrible feeling. But we can pick ourselves up and go back to what we have to do. This was life or death for their careers.
It was. And there are not many people in this world that can say that they've walked up to that line and looked death in the eye.
Yeah, looked into the pit of hell, basically.
And they did, and they won. And it was it was such a great feeling and great thing for Jeff and Ven, the firm, and people don't realize how important that was for the rest of the legal community as well.
You're right. Now, let me ask you a question that I heard a little rumor about, and I want to know if it's true, okay? Now that you're on Cases Gone Wild, we're going to set it straight. I heard that Jeff had a limo come to the federal courthouse after the verdict, which you're allowed to do. There's not unethical at all. And pick up all the jurors and go and have a huge party. Is this true? So, Jim Harrington, that's what we want to know.
This is as far as Cases Gone Wild. So after the acquittal, it was in perfect Jeff format. It was like Jeff knew he was going to be acquitted. There was never a doubt in his mind. And so he had already had lined up a limo bus, not a limo, but a full
like a party bus
lined up, and he shuttled, I kid you not, he shuttled every juror that sat on that jury and acquitted him and Ven, shuttled them onto the limo bus and drove them over to the Athenaeum. And there was
downtown Detroit,
the Athenaeum, and there was a huge party, acquittal party that we had. That the firm was there, family was there, and every juror was there.
Did every juror go?
I'm pretty sure everyone was there.
That's amazing.
Yep. And here's what's even better. So every year Jeffrey would host a holiday party.
Which is, by the way, if you've never been, it is one of the biggest parties I've ever been to. I mean, it's extravagant.
Oh, he's had the Knack play at the party. He's had Foreigner play at the party. We've had some very big acts play. We've had the Temptations play. So it's
always get a car home from Jeffrey Flegger's party.
It's an incredible party. But also on the guest list were the jurors.
Every year.
And every year there were 3 or 4 of them that would always show up to Jeffrey's holiday party.
That's amazing, man. Now that truly is a fitting end to a case gone wild.
It is.
I appreciate you sharing that. So, Jim, our firms do a lot of civil rights work, which is tough. I mean, you sue the government, it's tough. They have endless resources, and they get what's called an automatic appeal before trial in every case. Ben Crump, he's a famous civil rights attorney. He says that he does like a lot of civil rights. He says his civil rights practice is one of his least profitable profits.
Then he's not
firm.
Doing it right.
Yeah. Sorry. But tell us about a case that you did and that you tried, which I believe was the largest wrongful imprisonment case, the largest verdict in Michigan history.
Yeah. So let me set the stage a little bit with the office. At this time that I'm trying it, I'm a partner with Jeff. And in that role, I have my own cases that I handle. and that I would also help some of the lawyers in the office with their trials if there was ever a time. And one of our lawyers had been working on a case, and Jeffrey had asked me to step in and try it. And it was about 2.5, maybe 3 weeks before the trial started.
So you're having to jump in on a case that you
Yeah.
don't know much about.
Yeah, I mean, everything had been, all of the pretrial workup had been done. All of the motion practice had been done. Everything had been done, and I had 2.5 weeks, 3 weeks to learn a client, get to know the client, and figure out the client's story.
And for those who aren't lawyers who are listening, that's not a lot of time because these cases take years, right? And there's all kinds of stuff that occurs before we get to the trial. We don't just walk in and start trying a case usually. But I find it's really hard to have this very small amount of time to suddenly have to jump in. It's like, when we go to school and we take tests, you have kind of all semester to learn the material and get
Right.
ready for the test. Here, it's like, here's your study guide. Your test is in 2 weeks, right?
Yeah, it's literally like jumping in and taking a final exam without having the benefit of the entire semester to learn the subject matter when taking the final exam.
Yeah.
And I looked at that as a challenge because I had seen Jeff do it. I've seen,
Yeah.
Ben
Jeff jumps in the
Johnson
day
do it.
before,
Yeah.
you know.
and that's like we talked about earlier. So I get assigned to work on this case, and I get into it, and I start looking at it. And this case involved a man who was at work,
Okay.
and the Detroit police came into his work and arrested him.
For what?
For murder.
Did he murder anybody?
No, they arrested the wrong guy.
Why?
Well, the bad guy who had allegedly committed that crime had an alias that was my client's name.
So it'd be like Jon Marko, some guy kills somebody, he goes by Jon Marko.
Yep.
They come and arrest me.
And arrest you. And they come into your law office in front of all of your staff, and they say, come with us, you're under arrest, and they put your hands behind your back, and they cuff you, and you're sitting here saying, who are you arresting? What am I doing here? This isn't me. You've got the wrong guy. You've got the wrong guy. And that happened to my client. And this Detroit police officer who was in charge of this, arrested him and booked him. And the whole time he's saying, you've got the wrong guy. You've got the wrong guy. And so that's
horrible.
Yeah. And he spent 13 nights in jail in the city Detroit jail. And the whole time he was professing his innocence, and they just ignored him. And then all of a sudden they realized, oh yeah, we did get the wrong guy, and they let him out.
How'd they realize it?
When they finally found the bad guy.
Yeah. Oh,
so
the real Jon Marko,
Yeah,
right?
well,
It's
well,
like
the real
the
Jon
real
Marko.
Slim Shady. Please stand up.
and that's really what happened. And he didn't get beat up in jail. He didn't lose his job. But he did have his rights stolen from him.
So let me guess, without even you telling me the defense, it sounds like they screwed up for sure. So the defense that I'm guessing the City Detroit lodged was, what's the big deal? What's the harm?
Well,
Or-
they even took it a step further. They minimized the fact that they violated this man's constitutionally protected right. They minimized that, but they also said, well, we didn't do anything wrong. So they did the double whammy.
They did everything.
Yep. They threw every defense that they had.
And just so we're clear here, this guy had absolutely no connection whatsoever. He was completely innocent with no connection except having the
Correct.
similar name.
Accurate.
Okay.
Accurate. So I get involved in the case about 2.5 weeks, 3 weeks before trial, and I'm trying to figure it out and learn it. And we get into a court one day, and the city of Detroit had this big legal team that they were using to win the case. They
Yeah.
had multiple lawyers, and one of the head of litigation there.
Who was it?
Jerry Ashford. Great guy.
Great guy.
Great guy.
Just had a case with him against the city of Detroit. Smart guy.
Excellent.
And they have a whole, just so our listeners know, the city of Detroit has its own law department that has what, like 30 lawyers?
Yep.
And they can just bring in whoever.
Mm-hmm.
I mean, how many did they? The last case I had, they had like 5 lawyers.
They
on
had
the case.
4 lawyers. The lead trial lawyer was Crystal Crittenden.
Yeah,
who
very experienced lawyer. I know her very well.
So she did the trial. There was a second chair. I think that was Calvert Bailey. Super good dude. And Jerry Ashford, though, but he was involved in some of the pretrial stuff. And I'm starting to learn the case, and I'm really upset with what the government did to my client. And it also made me upset that the city didn't understand and didn't appreciate that, when you steal somebody's rights, it's a big deal. And they said, Jim, listen, we'll pay you some money on this case, but, they were talking, 25, 50 grand is what they were saying. And
would you take 25 grand to have somebody come into your work, say you're a murderer in front of your coworkers, and then put you in jail away from your family for 2 weeks?
Well, that's an interesting question you ask. And that's kind of what, and I'll tell you about that towards the end when I talk to you about what I said in my closing argument. And what I said to the jury at the end, and I'm going to kind of fast forward, but I want to come back to this. I said to them, you may go back into that jury room, and when you're considering the justice that is to be given to my client, and I explained compensation and money damages means lots of justice, and no justice is no money. And I said, some of you in there may say, how much would it cost? How much would you take to spend that night in jail? How much would it take? Would it take $100,000, $200,000? And I said, but that's not what we have here. Because in that line of questioning, you have a choice. You have a choice to either accept the offer to take those nights in jail or not. Your rights weren't stolen from you. Your constitutionally protected rights that members of our armed forces have fought for decades to protect. Those same constitutionally protected rights that our service members are fighting for every day to ensure that tyrannical governments and do not steal from us were stolen from my client. So that analysis of saying, how much would you take? How much would you take? That wasn't the case here. The rights were stolen. And so I wanted to get the jury out of that framework of thinking, because listen, Johnny, I'll tell you this. Hey, how about this? Why don't you go over into Wayne County Jail? I'll give you $100,000 if you stay the night. You're like, man, I ain't doing anything tonight. I'll take it.
Yeah.
But you had a choice, and my client didn't.
As long as they put me in a cell by myself, right?
Yeah, and I said, how arrogant to think that making a choice versus having somebody's dignity and human rights and civil rights and constitutionally protected rights to be stolen are the same thing. And it was really frustrating because the city, that's how they saw it. And they were trying to equate. They told me flat out, they said, Jim, we're never paying you 6 figures on this case. Are you kidding me?
Which means they'll never pay you $100,000 or more.
And you know what that really said is that our brain won't allow us to understand a rights violation and what it actually means to a human. And
it says your constitutional rights aren't worth that much.
Nothing. And that was really, I started to, as I was getting ready, these are the things that are getting planted in my brain.
Let me ask you one thing, Jim. Sorry to interrupt you, but getting ready on such a short time span of 2 weeks before you have to present a rather complex case. I mean, comparatively speaking, I always find it's really hard. And coming from a football background,
right?
I always Monday morning quarterback, even though I try not to, because I'm like, I would have done it this way, I would have done it this, or I would have done that. Did you find it challenging to get? to get ready
Yeah.
for a case that you hadn't seen in 2 weeks?
It was an incredible challenge because in the preparations for the trial, one of the things that are generally available are depositions.
Which is questioning under oath of witnesses
Right.
that you can look at and have and use.
And generally in depositions, you get to learn what the defenses are. You get to learn what the other side was thinking. You ask lots of questions. Sometimes, Johnny, the depositions go hours and hours.
Hundreds of pages.
Even if you're only going to put that witness on the stand for 15 minutes or 20 minutes, you may have a 4-hour deposition.
To cover all your bases. That way they can't
Right.
change their testimony once they can't say, oh, we should have said this or should have said that.
And when it came time to try the case and I figured out what witnesses I think I'm going to need to win this trial, I didn't have one deposition of any of the witnesses that I called.
You're kidding me.
Not one.
You didn't have one.
Not one.
Jim, I've never went into a trial where I didn't have one deposition at least. I mean, I want to just tell you right now because I know the result because I've quoted your verdict in this case on other people. In fact, Mike Steinberg, do you know who that is?
No.
He's the former head of the ACLU. He's now a
Okay.
professor at the University of Michigan. He called me a couple of weeks ago and said, we have a wrongful imprisonment case against the city of Detroit. We're trying to evaluate the case. Same players as in your case, you know? How do you evaluate it? How do you evaluate it? And I said, these are tough cases to evaluate.
Right.
Well, but let me tell you what my buddy Jim Harrington did. And I sent him an article about your case, and it was like, wow, you got to be kidding me. But we'll save that for the end. But I am amazed, knowing the result that you got, that you did not have depositions and these kind of tools of the trade going in, because that helps bring certainty and it helps us prepare.
Well,
so I think that goes to your skills as a trial lawyer. I mean, that's amazing.
No, thank you. You always, in the movies, they say never ask a question
you
that
don't know the answer
to. And I don't know if that's true or not true, but because sometimes things are organic in trial and sometimes things happen. I don't have hard, fast rules like that. But as I'm getting ready for the trial, I remember I was talking with Jeff Feiger about the trial. And, Jeffrey would always tell you what he would do, and he would say, this is what you got to do. But what he did, and he would do this with all of my trials, because I talked to him on every single trial I would do. He would tell me everything that I was doing wrong, and he would question if I was even a lawyer.
Yeah.
And then as we would get...
Sounds exactly like his advice to me. Yeah.
And then as soon as we got very, very close to the trial, usually like the day before or the night before, he would call me up or call me to his office, and he would have this real low voice and quiet voice, and he would give me almost what I call like a one-liner, and he would do it in every trial. And he said, in this trial, he said, be very sad and tell your story. And that's a one sentence, but it is compelling. Yeah. And so we get ready for the trial. There was no chance of a settlement. They weren't offering anything.
Sometimes you just got to go.
Sometimes you got to go. And so we started the trial, and it was, Johnny,
so let me ask you, was it all easy? Were you winning? In sports, we have momentum, right? You get the momentum, it's going, you can feel it. Like you said, Jeff knows he's going to win. Was this trial, did you know you were going to win from the beginning? Tell us what happened.
So we get into the trial, and I had a lot of anxiety because I didn't know what a single witness was going to say. And I was really in my head. We had brought in a phenomenal jury consultant, Steve Natt, he was outstanding, instrumental in the case to help me.
Excellent. I got his book somewhere on my bookshelf behind you.
I've got it too. And so we were getting ready for the trial, Johnny. And so I start picking the jury, and from playing sports, when you're in the pocket. I didn't. It was almost like it was my first jury trial. And
so our listeners know, when you're picking a jury, this is the only time in the trial that before the trial starts, kind of,
right,
you get up and you get to talk to the jury and have a conversation. They're talking to you. You're asking them questions, right? It's almost like you're at a bar or at a podcast on Cases Gone Wild.
I will go toe-to-toe with any trial lawyer that says that there is a more important part of the jury trial than picking the jury. It ain't the closing argument.
Yeah,
it
right.
ain't the cross-exam. It ain't the opening statement. It's voir dire.
And
jury
Jeff would always
selection.
say that. Jeff said you won or lost your case by
That's
the end
it.
of voir dire.
And because trial is a social process, okay? It's a social process in that these people don't know you. They don't know the other side. They
Yeah.
don't know your client. They're looking for somebody to trust. They know why they're there.
Yeah.
They know that they're there to hear a case. They've probably never been on a jury before.
Right.
They've seen it on TV, and they want to do the right thing. They're looking for somebody to trust, somebody to follow. And so this is your opportunity. And as plaintiffs, we have such a great advantage because we get to go first and
Right.
ask the questions. And this is the chance for you to introduce yourself to the jury. So in this trial, this wrongful imprisonment case, I'm up there and I don't know what it was. To this day, I still have to go back and figure it out. I wasn't communicating with him. It's like, when Aaron Rodgers or Tom Brady on the first play of the game, they throw a pick. That's exactly what I felt like. I felt like I was just making a mistake. I wasn't communicating. I felt like I didn't know my jury at all.
And I can tell you, there's not a worse feeling in the world, especially from the beginning, like you said, because you have to play the rest of the game, right? And if you don't have a good connection with the jury, you're questioning yourself. You're looking nervous, whatever it is, but you just can't get that groove. So how did you overcome this kind of first bad play, so to speak, to go and get this record-breaking verdict?
So here's how it happened. So we finally impanel the jury. And in my mind, I was like, these people don't know me. They don't like me. I can't talk to. It was just, there was this wall between us, and I can't even explain what it was there.
I felt it, and I think anybody who's listening who's tried a case has felt it too, or they haven't tried enough cases.
Right. And so then I feel like I had just fumbled or thrown a pick. So then I stand up to give my opening statement. So this would be like Tom Brady's second drive. I threw another pick. I delivered the absolute worst opening statement that I had ever given in any case. And it's because in my mind, I'm thinking this jury doesn't like me. They don't know me. Man, if I could just get a few other people on there, then they'd get to know who I am and I can tell my client's story. And so I finished my opening statement, and it was horrendous. I just threw the second pick of the game. And defense gets up and does their opening statement, and it was fine. It wasn't anything special, is what I had expected. Yeah. And then we rest for the day, and we come back the next day. And I'm getting into some of my proofs, and
for proofs, you're putting your case on.
Putting my case
calling
on.
witnesses.
Calling
exhibits,
witnesses,
whatever.
evidence. And then in one of the first or second witnesses, the defense flagrantly violated a court order on an evidentiary issue.
And so our listeners know, before a trial starts, the judge makes certain decisions on what evidence can come in or what evidence can stay out. Because sometimes there's rules and evidence should not be introduced into the trial. Like, someone committed a crime in the past that's not relevant or something. Right. We don't judge someone for their mistakes, whatever it is. And so there was a ruling. What was it, by the way?
It was some stuff in my client's background. There was some unsavory things in my client's background.
So it sounds like the same thing.
It's the same thing.
Yeah.
And so it had no bearing and no relevance on the case. So the judge
it's just to try to smear your client.
Correct.
Like, God forbid somebody put all my bad stuff from when I was young.
Correct.
All the stupid shit I did.
So that there was an order that said they can't discuss any of that.
And they just did it anyways?
And flagrant, as using a football analogy, it was a late hit. It was a pass interference. It was flagrant.
Man, I got to tell you, I like a lot of the city of Detroit attorneys, but man, I've had the same issues with violation of evidentiary rules and court orders that you're just scratching your head thinking, what are you doing?
Yeah.
I mean, this isn't a gray area, Jim. If a judge says you don't do this, you better not do it.
It's trial practice 101. You got to know where the boundaries are, and you have to stay within them. Now, Jeff, as brilliant as he is, he would push boundaries. He would push them, and he would test, but he would just stay
Jeff
in the
would
lane.
kick the sand a little bit.
Yeah.
He wouldn't just jump over the thing. Usually.
So I got up and I screamed, bloody murder on this. And I objected and I moved for a mistrial. And
so they know a mistrial is basically the judge says the game's canceled.
Correct.
Everybody go home. Sorry, your tickets are not valid anymore. We're going to do a rain delay.
Yep.
And do a whole nother trial later.
Pick a brand new jury, start over.
And did the judge do this? Because this is not common.
No.
For a judge to cancel the game, normally they'll say, all right, counsel, don't do that again, or they'll yell at them or something.
Right.
It takes a lot for most judges to cancel the whole game because they picked a jury, they've spent time.
Right. So I made a very long record, meaning that I laid out my argument for why I felt that I could no longer receive a fair trial for my client. And after I laid the record, they responded, and we went back and forth for a while. And then the judge agreed with me, which is, like you say, it's very rare. I mean, people will claim mistrial, but it's very rare to have it happen.
Yeah.
And so the federal judge granted the mistrial, and this was maybe on a Wednesday or Thursday of the week. And so he said, come back Monday, and we're going to do this all over again.
He didn't wait around.
Nope, he didn't wait around.
So just so we understand, the jury in that case was dismissed.
Right.
The trial was canceled midstream, basically.
Right.
And then you had to start a whole new trial. Pick a whole new jury, new people, right?
Jury, yep.
All right, so this is kind of a blessing, though, if you were feeling, I'm guessing, a little uncomfortable with how the game had started, because now you get to start over at the first quarter again, at the very beginning of the game.
Yeah, and it was funny because, at the first trial, the first part of this case, I had my notes and I had the outline and all of that stuff, and it was kind of, I think I was a little
too much
apprehensive in my head because I didn't have the depositions and I was worried about all the stuff that I didn't have. And you know what I didn't do is I really didn't take Jeff's advice of tell the story, be sad and tell the story. And so for round 2, I got completely out of my head. I don't know what happened. I didn't use any notes. I had everything just pushed aside. And when I went and talked to the jury, I'm talking to them like I'm talking to you now.
As you said Steve Natt was there. His book, which I finally found on my big bookshelf behind you, is called The Authentic Attorney.
Yes.
So it sounds like you became the authentic attorney on this second opportunity.
And in the second opportunity, when I was talking to the jurors, it was like I felt like I was at one of my hunting camps and talking to all of my buddies sitting around a campfire about what we saw that day and over a nice cup of chili. And it was like they were all my friends. It sounds cheesy, but I could tell you that I felt like everybody in that box, they were my friends.
It is. It's not cheesy because I felt it, especially on a case like that, where it's weird to say, but like I love them.
Yeah.
Like it's weird. Like I remember every single juror on some of my cases, and it's weird. There's like a bond there. I don't know how to describe it, but any good trial attorney, if you have that.
And so we were, we get these things, that are peremptory challenges where we can get rid of jurors. And generally in every trial, we use almost all of our peremptories because.
And so our listeners understand you get like, what is in state court, it's 3. I don't know if it's the same in federal court, but you just get to say, you know what? I don't like the way Miss Smith looks, basically, or
you can
whatever.
say anything as long as it's not an illegal reason.
Yeah, as long as it's not race or gender.
Yep.
So you can say, Miss Smith reminds me of my ex-girlfriend.
Right.
I'm going to kick her off the jury. You get 3 of those. But did you not even have to use those?
I think I used 1, maybe 2, and I didn't even really want to get rid of them. But there was something there that we were
better
a little
safe
concerned
than sorry.
with. Yeah. And so I felt great about the jury. I felt that they cared about. I felt that they were going to care about what I had to tell them, and care about my client. And so we pick the jury, and then it comes time for opening statement. And I got up and I did what Jeff said. I did forget the outline, forget, members of the jury, the evidence in this case will show. No. I just told the story, and I was very sad about what happened and how this man's rights were flagrantly violated. And so I sit down after my opening, and I said, I'm going to win this trial. And I felt it when I had picked the jury. I felt that I was going to win.
Yeah.
And then after I sat down and delivered an opening.
Well, there's little things, man, and it's indescribable. Sometimes, I don't say I know everything. I don't know if I'm going to win or not. Sometimes I have a pretty damn good feeling.
Yeah.
And then sometimes
you just know. So we get into the witnesses, and it was like, from the first game, remember I threw the two interceptions. It was like almost every play it felt like an 80-yard touchdown, and everything felt like it was going my way. And it was an incredible thing, because without the benefit of having the deposition, it was almost better, because I was able to Jeffrey would always say, Jim, you have to tell this story. Jack and Jill went up the hill, blah, 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 blah. This is the witness. You don't care what they say. To fetch a pail of water, blah, 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 blah. And that's how I tried this case, is I just went through and explained what had happened. And, part of the case was that, that he was professing his innocence when they arrested the wrong guy. And I was saying, an officer, the whole time that you're walking him out in front of his staff members and his coworkers into the car, he's yelling to you, you've got the wrong guy. This isn't me. I didn't do these crimes. He was saying that, wasn't he? I don't care what he says.
Yeah.
I don't care if he says, yeah, that's what he was saying, Jim. No, that wasn't it. Doesn't matter what that witness was saying. I just told the story, question after question after question. And there were some really cool aha moments, and a lot of things that were just, there was a lot of government cover up, a lot of government corruption type of themes that I was trying. And the evidence, it was a fairly short trial. It was only about a week long. And then it came time for getting ready for the closing argument. And so I was working with Steve Natt on this, and he was suggesting that I ask for, a dollar amount of $5 million. And again, my client had only spent 13 nights in jail, and to ask for $5 million.
And what were you thinking? Like,
I was, at like $1 million, $2 million, something like that. And I'm like, I was like, Steve, how are you getting to this 5 million? I mean, I've got to believe this number. So listen, I trust you. Help me see it how you see it, because as you tell me 5 million, I believe you. But if those numbers come out of my mouth and I'm not there, the jury will know that I'm lying to them.
And just for people who've never had to do this on our side, believe it or not, asking for money is one of the hardest things that I've ever had to do on a case. And I don't know why. I don't know why it's so hard, but I think it's hard for most of us, especially those of us who haven't come from a lot. I didn't have a lot when I was young, and it almost is like shameful in a weird way that to ask for money, for me at least. And that was one thing I had to overcome. And also, how do you value something like this? It's very difficult. And so I always find that asking for money to be one of the hardest parts of the trial. I don't know how it is for you.
Yeah, it's very challenging, and you're absolutely right, John. And when Steve had worked with Jeffrey for decades. Yeah. And so he's used to Jeffrey, where he would ask for 50 million or 100 million on cases. And on his case where it was only 13 nights in jail, and he didn't lose his job, and he wasn't beat up, and he did have his rights stolen from him. Steve's talking to me about $5 million, and I just wasn't there. So I go, listen, I'll do it. Help me. work with me. And so we spent a lot of time, and then Steve came up with this example about, death benefits being paid to service members who die while in the line of duty. And I believe that he told me, Jim, listen, there's a death benefit of $150,000 that's paid, and you need to work in that the rights that were stolen from your client are rights that all of these service members are protecting. And dying for. So you need to, and I was like, all right, I'm seeing it. And so I got to the point where not only did I believe that 5 million was a good number from trying to reframe my brain to understand, the rights violation, but I'm like, heck, is that even enough?
Yeah.
And so it was very easy. And then when it came time to deliver, the closing argument, and I walked right in front of the jury, and I talked to them, and I explained how important their role is. And I explained that today is the only day that my client will have to have justice delivered. And whatever you do, jury, whatever you write will forever be enshrined in this courthouse. The verdict that you write will always be here. So when our children's children ever want to see how justice was done on this case, it'll forever be there. And I explained the importance of it. And I explained the importance of what our rights actually mean. It's not some token thing that we just say, oh, you violate. No, this is real. Think of the bloodshed that American citizens have fought for, going back to when the Constitution was written all the way through the present with, and I explained how important and how ingrained, and that we can't just give it token acknowledgement. And so I really tapped in, and I finished, and I asked for $5 million, and I felt good. And so the defense gets up, and they did a really bad job, respectfully.
Yeah.
And so then I had a chance at rebuttal. And then the judge gave the jury their instructions, and then they left. They went into the back room.
How long did it take?
Well, here, as you know, John, the longer a jury takes to think about a case, and sometimes we get that great question that says, can we use a calculator?
Yeah.
Or, is there a limit on how much we can award? Those are great questions. And so, but there's like this rule of thumb that once they make it to the 4-hour mark, you're generally good.
Yeah.
And a fast jury is bad.
A fast jury is bad for us. And just so people understand, because they have to fill out a form.
They have to fill out.
It's they don't just write on a Post-it note, plaintiff wins, here's the money.
But it's even more than that, Johnny. It's federal court. It's got to be unanimous.
That means every single juror has to agree.
So,
and it's a lengthy form, I'm assuming, too, for a civil rights.
Yeah,
we
had state law claims, we had federal claims, we had punitive damage request.
Pages. So pages.
It was about 4 pages.
So how long did the verdict take? Because if it was a short verdict, I'm going to be nervous.
So here's what happens. So I'm sitting there, and everybody's kind of packing up and just kind of decompressing, and we haven't even left the courtroom. And generally you go to lunch, you do all these type of things. And so it's a Friday, love Friday verdicts. And so it's a Friday, and I'm sitting there with Steve, and maybe, I can't remember how long went by when there was some rustling, and then it was 45 minutes. And the bailiff walks over to the judge or the clerk and says, "We have a verdict."
Okay, so now if that's me,
45 minutes,
my head's gonna drop down, and I'm gonna be very somber and sad because I'm gonna think that I had just lost that case.
Steve looks at me. He looks over at me. He was sitting to my right. Looks to his left, and he goes, "Oh fuck," is what he said. And I slunched in my chair. I was like, well, I guess it is what it is. I mean, at that point, I swear to you, there was I went from thinking that there was nothing I could have done wrong that whole trial to literally in that moment, I felt about that
Yeah,
big, and
I've been there,
I
Mom.
said, well, I tried a good case, and I was just ready to just accept the the loss, and so not accept it, but I knew that it was going to be my fate and my client's fate, and so I've got the verdict form. And I've got my pen, and I do this in as they read, I write stuff down. And the very first question was, did defendant violate the plaintiff's rights in one or more ways claimed by plaintiff? Yes. And I looked at Steve, and he looked at me, and he grabbed my wrist. And then as they were filling it out, what amount do you award? What amount do you award? And the total verdict in the case for 13 days in trial was $3.5 million.
That's a great verdict.
Yeah.
That's a great victory that you should be very proud of, especially under the circumstances.
Yeah, it was really cool. It was
the largest wrongful imprisonment verdict in Michigan history.
Yeah, that's what I believe.
Understand.
I mean, that's how it was reported, and it was published in the news that way.
Yeah.
And nobody called me up and said, hey, I got one bigger.
Yeah, and I haven't heard of one, and I've looked, dude.
Yeah.
And I've looked. Well, this has been great. And, we could talk for the next 10 hours about cases gone wild between us.
Right.
But I wish we had more time. But this has been great, man. And I really appreciate you coming on the show. I know you're doing great. The Feiger firm's doing great. Jeff's doing great. So this was just a pleasure. And, man, crazy cases.
Crazy cases.
And I understand you're going on a nice trip. You're going on a hunting trip in Alaska, which you really like to do soon. So that'll be nice to get away for a little bit.
Yeah, it'll be an Alaska hunting trip, do it yourself, unguided, surrounded by grizzly bear, wolves, and maybe I can find a couple caribou.
Well, it won't be too different from our trial lawyer lives where we're trying to hunt our prey and keep wild animals from attacking us and stealing all of our stuff.
Eat what you kill.
Yeah. Jim, thanks a
Johnny,
lot, dude. It's been awesome.
Stay in the fight.
It's been awesome.
Thank you.
Hey, everybody. It's been awesome. Thank you again for listening to our latest episode of Cases Gone Wild, brought to you by Marko Law. If you or someone you know needs legal representation, needs help, please don't hesitate to reach out to us. You can give us a call, or you can go to our website, www.markolaw.com. We'll see you next time on another episode of Cases Gone Wild.